The Media Council paid the judge's call of the Attorney
General this morning, essentially to follow up on issues relating to the bills that touch on the media industry. These are 4 bills. One is the media bill, second is the data protection bill, the third is the freedom of information bill, and the fourth is the ICCK bill, the Independent Communications Commission of Kenya bill. What the Media Council wanted to understand is where the process of developing these bills and enacting them in Parliament is at, because as you are aware, in the Constitution we are given about 3 years to have the bills put in place to conform with the new Constitution. And the Council has consulted with the Attorney General this morning, and we would want to just let you know where the position of all those bills. As to what the Council has had, together with the other stakeholders, a fairly exhaustive consultation on the media bill, and the last discussion that the Council held was to bring together all the stakeholders, and after bringing together all the stakeholders, make the necessary suggestions and refer those suggestions to the government officials for drafting. And after the drafting, the bill was going to come back to the stakeholders so that the stakeholders can be sure that the discussions that had taken place with regard to those bills is reflected. The Attorney General has just confirmed to us that that bill will be coming back to the stakeholders so that the stakeholders can check to be sure that the discussions that had taken place are reflected on the media bill.
My view is that the government of the Republic of Kenya respects the rule of law, it respects the independence of the judiciary, respects the right of judges to make decisions, including decisions that we may not agree with. In respect of the case that you have made reference to, the Attorney General has today appealed against that decision in the NHIF matter. We have requested that the orders given by the judge be vacated because the Attorney General is of the view that those orders were made without full consideration of the law. In fact, in one sense, the orders were directed at the presidency. Under our constitution, the new one and the old one, the President of the Republic of Kenya cannot be made the subject of any civil or criminal litigation. Again, we thought that was a mistake. We also thought that the judge was in error not to appreciate that the interim body was created specifically to permit investigation into what was alleged to be improper practices, improper and irregular practices. We have requested that the file be placed before the judge at the earliest possible opportunity so that that matter may be ventilated before the judge. As to the merits or demerits of that, the Attorney General is a litigant like any other litigant in court. He may lose, he may win, but he still has to respect the outcome that the judge has placed on record. We believe that the reforms taking place in the judiciary are important. We support those reforms. The Attorney General is a member of the Judicial Service Commission, so we support the reforms that the Chief Justice is making. But we also appreciate, like you say, that we do need that courts should be able to appreciate the impact of decisions that are made. And I will say no more because we will be in court on Friday. Thank you very much, ladies and gentlemen.